I just wanted to start off by talking about communication for a minute. Communication is so important in all aspects of our lives, no matter who we're dealing with, whether it's in work, in our relationships, with our children, with our ex, or in the courtroom. Communication really matters in the courtroom. But I think what really impacts what happens in the courtroom is the communication that happens before you get to the courtroom, either the communication that's happening or the communication that's not happening. And I've mentioned how I once had a client who refused to respond to the other side's attempts at communication. The other side would reach out and my client would not respond. And this happened. It went on and on and on. And my client had a good reason for not wanting to do it. He thought the other side, was a narcissist and he didn't want to engage. So instead of putting out the canned responses that like Tina Swithin recommends, for example, and I had Tina on my live stream, it was about December of last year. Check out that live stream if you haven't. But instead of just putting in a non-confrontational kind of boring response, what the client chose to do was not respond at all. And what ended up happening in that case was that the judge said, listen, buddy, you are not responding to attempts at communication. You're not communicating at all. You're failing to communicate, which means to me that you're not co-parenting. So I'm giving the other side sole custody or sole legal decision making. I understand that sometimes it is hard, it is problematic communicating with your ex because they may be a narcissist, they may be a sociopath, they may really make your blood boil. They may send emails to you that go on and on and on and on for pages and pages. But, for most of these emails, you really should be setting forth some sort of response. And again, I suggest that you look at Tina Swithin's website. I think that on Instagram, she has a link for those canned responses. At the very least, respond that way. Check out Tina's book. Also, it's called The Narc Decoder. And in that book, she goes through different scenarios where, her narcissistic ex sent her emails that were annoying and offensive and how she responded. So you get some good examples there. First of all, with communication, it's really important that you respond as much as you can. The second thing about communication is that you should be saving those responses because you never know when they are going to become helpful. And I've had many cases in the past where communications from the past year or 2 years really are what win the case for us. The third thing about communication is that when you're communicating with the other party, you should always assume that you're being recorded, especially in this day and age, because you might be. I've had many of clients who didn't know that they were being recorded. And when evidence was disclosed to me in the scope of pretrial preparation, there were voicemail messages where my client was a part of them, and they just weren't good. They were, telling the other party to F off or just not good. So as hard as it might be sometimes, always assume that you are being video recorded or audio recorded. Now, what if, you want to communicate with the other side? What if there are frequent issues that you feel like need to be addressed and you want to send communication to the other side? Then really, in my mind, you should keep your communications brief. You keep them short. Limit the number of points that you want to make to the other side. I would say to a few, 3 or 4 points per email. And stick to the facts. No personal attacks on the other side, no insults. And I know once in a while, because sometimes I want to do it when I'm dealing with an attorney I don't like. Sometimes you want to throw in a zinger. Sometimes you feel like it just make you feel good. But, especially if you have an ex who is a narcissist, really that's what feeds them. That's what fuels them. And you don't want to do that. Keep your emails plain, keep them brief, stick to a few points and stick to the facts. And again, log those emails that you're sending to the other side. Another thing about communication is that, it's a fine line between communicating appropriately and communicating excessively. I have had in the past some clients who have nothing but the best intentions. And, maybe quite frankly, they've been a little OCD. So when a person communicates and they don't get an instantaneous response from the other party or even a response within 24 hours, then they're emailing again. Then they're emailing again. even though the other side may not be responding, if you're emailing them every day, you could come off looking really pushy and annoyed. So when you're emailing, I would allow the other side a quote reasonable amount of time to respond. What's reasonable, I guess, depends on the situation. If there's an issue that's time sensitive that needs an immediate response, then maybe you need a response within 24 hours. If that's the case, then I would put that in the email. I would say this is time sensitive and I need a response quickly. Don't put that it's time sensitive if it's not time sensitive, if you really could sit and wait for a response for a week or two. Another trick that I learned early on practicing is that when you're emailing, for me, I learned it in terms of emailing other attorneys, but it could apply to other parties too. So if you're emailing a party or an attorney and you want a response within a certain time period, then put in the time period that you would like the response. Say, please respond to me, within 5 business days or within 7 calendar days. And that way it kind of puts a trigger, hopefully, in their head that they need to respond. I once had an attorney tell me, listen, if you don't put that in a letter that you send to me or an email that you send to me, that you want a response by a date certain, then I'm just going to figure it's not a big rush and I'll respond when I get around to it. So that's another little tip and trick. Put boundaries around when you would like a response and then honor that boundary. If you say, you want a response within 5 days, then give them the 5 days. Don't continue to bug them, every day up until the 5 days. Once the 5-day hits, then yes, you can say, I'm boomeranging you and I'm following up. So there are so many good tools and apps that you can use to help in your communication. The Talking Parent, that's a really good app. Our Family Wizard is a good app. The Mail Track, I don't know if that's the actual name of the app, but it's essentially tracks emails and when they're open. I put that on my email, and I'm sure that there are others out there. So with communication, more isn't necessarily better. You really have to walk that line between not enough and too much. And of course, if your communication is accusatory, disrespectful, blaming, that's never going to go over well. And I don't think there's anything that judges like less than having to read 10, 20, 30, 40, or 100 pages of text messages at a trial of people pointing fingers at each other. If you stay on the up and up and stay respectful, stick to the issues and stick to the facts, I don't think that you'll ever regret it. I'm not saying that you are going to win the case if you do that, but at least, you're going to be the one that has the clean hands. You're not going to be the one that is pointing the finger with dirty hands. It only takes really one mess up, one time where you're telling the other side to, F off. You're cussing them out during an email, and that really can destroy you in front of some judges. There are other judges that give people the benefit of the doubt, but more often than not, I've had judges really hold it against people. One case that I had many years ago, the other party called and left just a horrific, just a cussing out message on my client's answering machine back when we actually had answering machines and not voicemail. And we played that as evidence at trial, and it just turned the judge off. The judge was so upset. And, that voicemail really encapsulated what the other side, the mom, was thinking about my client. And based on that, the judge did award my client sole custody decision-making, and he became the primary residential parent because the judge found that the mother was not capable of co-parenting and that she was disrespectful and that maybe she had some mental health issues.